It's Dallin Call from Dallin Call IP Law again, here for some more IP talks. Today let's talk about what will prevent you from getting a patent. In IP law, there are a few statutes that you need to be aware of. We mainly stem from 35 USC sections 101, 102, 103, and 112 is a good one to know as well. But when we talk about statutory bars or something that can bar you from getting a patent if you do certain actions, we might mainly consider 35 USC 102, section 102. In section 102, that will basically tell you that if you do certain actions, the patent office is going to reject your patent. For example, in most countries, we require a perfect novelty, or your invention has to be completely new or unobvious. And if you go out and use your invention, obviously it's not going to be novel anymore because it will have been used in the public domain or somewhere that people might be able to see it. And so what we recommend is that you file a patent obviously right away. However, in the US, we have what's called a grace period. There's a 1-year grace period that attaches to uses or other actions such as public sales or so for example, if you take your patent and you go out and you use it or have a public disclosure, such as what many universities will do, is they'll publicly disclose their invention first, and then they'll go in and get a patent on it. You have a 1-year grace period in the United States, but in other countries, if you're going to file foreign patents, you don't have that same grace period. So that's one thing that can prevent you from getting a patent under 102 is using your invention publicly. And especially if you're doing it in the U.S., you do it beyond that 1-year grace period, then you're barred from getting your patent. And like I mentioned earlier, there's a public sale or anything that is a sale, really. It could be any contract for sale or purchase agreement that you've signed regarding your invention. That can bar you from getting a patent as well. Again, you have the 1-year grace period, but again, if you're going to file in foreign countries, then you don't want to take advantage of that. You won't have that 1-year grace period. Just a little nuances regarding the 102 statutory bars. You do have some exceptions, such as experimental use. If you are experimenting on your patent or on your invention, and then you can still get a patent on it, but it has to be documented. You have to document all the different steps that you're taking and all the different changes that you're making to the invention underneath your experiments. And so, that's just a few of the statutory bars. Again, we're going to talk more about this later, but statutory bars are things that will prevent you, if you do it, and from getting your patent. It's called a bar. It bars you from getting a patent. Public use, public sale, and public disclosure are all things that can prevent you from getting that. But you do have 1 year in the United States after you do those actions. Anywhere else, or most anywhere else, you're not going to have those same grace periods that the United States has. So go ahead and get out and get your patent if you're doing some of those things. And if you've already passed that 1 year, then you're going to have to make some adjustments, more novel and unobvious adjustments, so that your invention can get patented. Anyway, that's all for today. We'll see you again next time.